Hi, in this immigration law update video, I just want to give you a quick summary of the guidance we've had so far in relation to tribunal hearings during the COVID-19 coronavirus outbreak and the measures the government have introduced. So we've had a number of statements so far. On the 19th of March, we had coronavirus COVID-19 message from the Lord Chief Justice to judges in the civil and family courts. Secondly, on the same day, we had the pilot practice direction, contingency arrangements in the first tier tribunal and the upper tribunal from Sir Ernest Ryder, the senior president of tribunals. And then finally, yesterday, Saturday, the 21st of March 2020, we had a response by Michael Clements, the president of the first tier tribunal, Immigration and Asylum Chamber, to a letter that ILPA had written. I've put all those letters online, links online from my Twitter account and my LinkedIn profile, so have a look at those to read that guidance for yourself, and it is worth reading. As you may have gathered, I'm recording this on Sunday the 22nd of March 2020, so it's early days and things are obviously subject to change and development, and you should check online for the latest guidance. It seems what is happening is there's going to be active case management of hearings. Some cases will proceed without a hearing. Others will be dealt with electronically. So in Michael Clements' response issued yesterday, he says already we've taken steps to increase the cleaning regime in the hearing centre, reduce the float list, which is always a good thing, and had a pragmatic and prompt response to adjournment requests for those who are unwell and self-isolating. From Monday the 23rd of March, and for Monday the 23rd of March and Tuesday the 24th of March, there will only be a handful of substantive hearings listed in order to maintain social distancing. Then from Wednesday the 25th of March onwards, there will be no face-to-face hearings listed in any centre. What seems to happen is then they're going to work towards working remotely. Notices will be sent out and then there will be case management. And doing that case management, there'll be a decision made whether the appeal should proceed without a hearing. You'll be able to lodge submissions and evidence electronically. So it's important when you receive those notices to look at them, address what they say. You may need to make submissions on why your case is not suitable to be dealt with without a hearing, but keep an eye for those notices coming out. If a case can't be dealt with without a hearing, the hearing will be dealt with by electronic means, and he suggests by using things like Skype and Microsoft Teams. So it's worth practitioners certainly making sure they're familiar with apps like that and things like Google Hangouts and Zoom in order to use these technologies to be able to be flexible and facilitate appeals going ahead during this time. The President also talks about the reform project and the asylum pilot that's currently ongoing with the electronic asylum appeals, and I think there'll be a continued rolling out of that during this period. I'm not sure in what state the Home Office are in order to respond to this and how they'll be able to engage with this process. I suppose if a case can't proceed electronically, it may need to be adjourned to the future when there can be a face-to-face hearing. So I think it's important for practitioners to be aware of this, to engage with any notices that are sent out and to respond to them, and then to be familiar with the technology in order to help appeals proceed. Certainly at number 8 Chambers, if you need help with any of this, do contact my clerks and I'm sure we'll be able to help. I hope this is helpful. Do monitor this ongoing situation and have a read of these practice directions for yourself. I hope that's helpful. Stay healthy.